早晨各位，我哋
Good morning, members. The Bills Committee on Private Columbaria Bill is now called to order with a quorum. We've reached the appointed hour. We will continue with a discussion with the administration. Now, please invite the officials into this room.
好早晨。今日
Good morning. The officials attending today's meeting are the Deputy Secretary for Food and Health, Mr. Christopher Wong, and PAS, Ms. Diane Wong, Ms. Chu, AD, from the Planning Department, Ms. Che, AD, Ms. Olga Lam, AD, Lands Department, Ms. Yu of Buildings Department, Senior Seasonal Draftsman, Ms. Phyllis Cole, Government Counsel, Ms. Cindy Chok. We have received the reply of the administration in respect of our discussion at the last meeting, and that is 431-1415-01. Well, perhaps I'll give the floor to the officials, and then I see whether members have any questions. Chairman, are we going to introduce a paper or what? Paper 431-1415-01.
好，多謝主席。咁就好多謝主席今次。
Thank you, Chairman, for giving us the opportunity to brief the Bills Committee on the building-related requirements in the bill, which was discussed at the previous meeting. If the Chairman permits, then we will present with the aid of PowerPoint. We will provide the background, or rather, we will make reference to members' questions first, and then as for our response to the questions, we will review on the background, the overriding principles, the coverage. The provisions are rather complicated, so we will first speak on the definition, and then after that you will have a better understanding of the provisions, and then we will speak on the regulatory requirements, and then I will conclude. If members may recall, a member asked about the licensing an exemption for private Columbaria. Some structures or construction works are permitted, though they might be unauthorized building works. What exactly are they? Now, let me first speak on the background. During the public consultation, we received quite a lot of views. Many hoped that we would adopt a practical approach in dealing with a question left over by history, and try to avoid large-scale relocation of ashes interned in Columbaria, and we have to take care of the feelings of the neighbors and the community. We try to reduce the adverse impacts of the private Columbaria. We need to find a suitable balance between the two. In making the suitable arrangements, we have to make it. We only have to do something that is necessary, reasonable, and proportionate. We have guiding principles in drawing up the measures. We have to take into account the special circumstances or background of the private Columbaria. They are existing users, and we should adhere to the current building safety standards, which we will not compromise, and we adopt a risk-based approach to formulate building-related requirements. Let me now speak on the coverage. As for the application for a license or exemption, anything that is within the application will be subject to the building's ordinance. What will they consider? They should comply with the requirements in respect of buildings prescribed in the bill. Now we adopt a comprehensive approach. There are conditions under which Buildings Ordinance Cap 123 does not apply. Say, for example, a structure on government land. That is something exempted, but we will put it under consideration if it is within the application. And Section 14 of Cap 123 applies. It means that any such works have to seek prior approval of the building's authority before works can commence. But if they have breached this, then we will take that into account. And finally, the licensing board sees it fit to specify something under the bill. This is a catch-all provision. If there is anything unforeseen now, we can still deal with that in the future. Say, for example, in the building plan was lost. Then the licensing board, will have to specify the requirement of specification and certification. Now, as for the above situation, they have to be done through an AP or RSE, i.e. they have to be certified by AP/RSE to prove that the structure is safe. Otherwise, the licensing board will not consider the approval or the application. Now, if I say AP/RSE, then that will be a mouthful. That may not be so easy to understand. I just say a professional certification. That means certification by AP/RSE. They certify that the building is safe. Let me now turn to the definitions. The first definition, what's meant by compliance with building-related requirements. In Schedule 2, Section 3.1, there is a clear provision. The Columbaria complies with requirements for approval and consent to the commencement of building works under Section 114 of Cap 132 and every other requirement specified by the licensing board.
In other words, they have already got the approval from the Buildings Authority before works commenced. And also, with regard to, the structures have also complied with all the other relevant provisions in the bill with regard to the structure, and they will also have to comply with all relevant provisions in the bill. The reason why we have to have this That's because we would like to require them to have the building certified by APs and RSEs. And secondly, for such Columbaria, and also on top of them, or in the building itself, with regard to the building structures and also the structure itself, they will have to comply with relevant provisions. And of course, that's not just about CAP 123. It's also about certifiable buildings. What does that mean? Well, if Mr. Liang Chi-Chang, you asked last time, you also talk about 1961 and 1987. In the new territories, there are small houses and so on. I'll be explaining in a moment. With regard to certifiable buildings, actually, the term would apply to those structures and at the time of their construction. For example, taking those that have been constructed after 1987, they might have applied to the Lands Department for exemption. That's why they have not breached. Well, let me put it this way. That is under Section 14 of CAP 123, the provision doesn't apply to such small houses. And so there is no question of these structures breaching the relevant provisions. But then at the time of their construction, we did not foresee that those structures would also be used as Columbaria. That's why we say that they will have to be certified by professionals to the extent that they are structurally safe before a license can be issued to them. So that's the first condition. And the second term, which we would also like to explain. So, well, for APs and RSEs certifying the buildings, so by that, what do we mean? Well, for these APs, authorized persons, or RSEs, or registered structural engineers, and if you look at Section 2.1 of CAP 123, with regard to the interpretation of certain terms, here we have the detailed explanation. So, by a system certified by authorized or by APs and RSEs, as we have also spelled out in the bill, that these APs and RSEs will have to certify that these structures or buildings are structurally safe to the satisfaction of the licensing committee or licensing board that they are structurally safe before the licensing board would continue to process their applications. Well, the licensing board, upon vetting their application, might say that you will have to carry out more works. For example, in terms of the means of escape, you will have to do a bit more. So the licensing board can impose further conditions. And so despite the fact that the structures might have been certified by APs and RSEs, the operator will still have to meet the requirements imposed by the licensing board before the licensing board would consider issuing a license to them. Because under CAP 123, the licensing board would look at the situation, i.e. if the BA has already taken a look at it, then of course the licensing board would have a greater confidence in the operator. But then through this certifying mechanism, the licensing board will have to be satisfied that the structures or the buildings are safe before the application by the operator would be processed. And as I said earlier, we talk about being able to comply with the BO's requirements, that is under Section 14 of CAP 123. And also we have looked at the term certifiable buildings. That's because the buildings will have to be further certified if the structures are to be used as a columbarium. And what does that mean? In the bill, there are also very clear definitions. So here we mean that for buildings that do not fall into the description under CAP 123, Section 14. Because if you look at Hong Kong's development process, at different times, buildings have been built. And what do we mean by that? For buildings that have been built after the 16th of October 1987, maybe I can start from an earlier date. In fact, on the 1st of January 1961, so before the Buildings Ordinance was enacted in the new territories, when you go there, well, you would have seen those buildings already. So it says here that for structures or buildings that have been built before the 1st of January 1961 in the new territories, so for buildings that have been erected or built after the 1st of January 1961 without any further additions and so on, if they have been redeveloped, then of course they would also fall under Cap 123. And then between the 1st of January 1961 and the 16th of October 1987, in fact, during that period of time, the administration also introduced further rules and regulations. That's the BO, anti-exempted houses, but then that was already repealed in 1987 because that was already replaced by Cap 121. So for small houses built in the new territories, there was no requirement for them to apply for an exemption so long as they can fulfill the requirements with regard to the dimension and the specifications. Then those houses would be dealt with under the new law ordinance. And of course, we have to move with time. That's why on the 16th of October or thereafter, that is in 1987, these buildings would come under the Buildings Ordinance bracket applicable to the New Territories Ordinance, that is Cap 121. And the distinction between this and the earlier enactment is that they will have to apply for a letter of exemption from the Lands Department, and if they fail that, then they would again have breach Cap 123. So under these three situations, as we have just said, they have their own set of legislation to regulate them, and therefore we can't say that they have breached Cap 123. We can only say that they are non-compliant with Cap 123, and therefore if they fall under that category, then we would deem them to have complied with the requirements under the Buildings Ordinance. Before I move on to that, let me again supplement on this. There is another scenario under which you might ask under subparagraph A, that is under Cap 121. So in other words, they've only come up after the 16th of October 1987, and they've already applied for an exemption from the Lands Department, so they would be deemed to have complied with Cap 123. But then if they failed to obtain that letter of exemption, then they would fall under the description that we are going to explain later about non-compliant buildings. So it's not that so long as they are in the new territories and so long as they have been built, then they would be deemed to have complied with the relevant legislation. So they will have to apply for a letter of exemption, and if they have failed to do that, then they would be deemed to have breached Cap 123. Moving on, just now I talked about buildings in compliance with the Buildings Ordinance. Then we would like to turn to the next term, that is non-compliant buildings. And here we refer to Schedule 2, Part 1, that is about the requirements under the Buildings Ordinance. And if they fail to comply with those provisions, and if they have been constructed in that manner, then we would call them non-compliant structures. So how will they be dealt with? Under the bill, there is a term. We call them structures certifiable for a pre-built columbarium. Well, it's a very long term. That's why you might find it difficult to understand. In fact, we are just referring to structures that form part of a pre-built columbarium, and then we will only look at those. And there is a time frame that is very important. That is the cutoff date. As members might remember, that is the bill announcement time. That is 8 o'clock on the 18th of June 2014, and that would determine whether a columbarium would be treated as a pre-built columbarium. So it is a cutoff date, and if the columbarium only comes about after that date, then we will not be looking at the substructures certifiable for a pre-built columbarium and so on and so forth, because the cut-off date is 8 o'clock on the 18th of June 2014, and only structures that have been built before that date and time will be considered. And by that we mean that right after the cut-off date, if the structures have been built and if they have complied with the definition of structures non-compliant with the relevant provisions, the definition is very narrow. It doesn't mean that so long as they can come up with any structures that are non-compliant, they will still be treated or processed under the mechanism, because that would cause nuisance to the neighbors. So we are talking about niches in the columbarium. If they've already been used, for example, there is a row, and then some of them have already been entered and others not. So at least one niche in the columbarium has already been entered with ashes. In other words, the niche has been used for that purpose, and then we will consider the replication. It's not like when they have all the niches, but then none of them have been entered, and still we will consider their application. And also, they would also have the necessary ancillary facilities for the operation of a columbarium. So they can't just come up with any features or facilities that have nothing to do with a columbarium, and then we will still consider their application. It's not the case. And as we have said, we will have to adhere strictly to the requirements under the BO with regard to building safety. That means that we have also got some conditions under which the application would be considered. So for the outdoor facilities or structures other than the niches, and it has to be a single-story building, and usually that's on the ground floor level, but then I'll be elaborating further. So we are referring to the structure at grade. So there is this one-story building, and if they are at the ground floor level of a multi-story building, so it's only confined to the ground floor and also the base, and for the upper stories and also the basement, they would also not be considered, because we say that it doesn't belong to any other story of the building itself, either the upper stairs or the basement, so only the ground floor level would be covered. And as we just said, we refer to the dates of 1961 and 1987, so only Cap 121 and also previous legislation, only where they have complied with those will be treated as okay. Or if they have applied for a letter of or if they have failed to apply for a letter of exemption, then they would fall outside of the category of structures certifiable by APs and RSEs, i.e. they've already breached Cap 123. And for the avoidance of doubt or dispute, the bill would also make it clear, as we just said, if they are on government land which is unleased.
We say we may consider that, but people will argue that since Cap 123 doesn't apply, since it is on crown land, and under Cap 28, an application, a license can be obtained from the Lands Department. If concerning the license, the land license is a land document issued under, is a title document under Cap 28. It is different from buildings. The licensing board may consider the application. That's for avoidance of doubt. Some may argue, you said that a single-story building. Now that means the ground floor and nothing else. If it is a UBW, which is inside or on top, we have already spelled it out very clearly that that will not be covered, or that will not be dealt with. Let me show you with some drawings. I'm not going to use local examples. This is not to prejudice the licensing board. It is up to the licensing board to approve or not to approve. So the examples are just drawings, or they are initiates in other parts of the world. Now this is the ground floor outdoor structure. And that's rather simple. That is a single-story building, partly used or completely, or it's wholly used as a single-story building. And then multi-story building. Some may be very big, bigger than very small houses. The ground floor, only the ground floor is used for niches. Those on top will have to be dealt with by the operator or applicant. The licensing board will not deal with those on the upper floors. As for those that are in line with very small houses, they have not seek any exemption, or they have not applied for any exemption. They have to get certification and to the satisfaction of the licensing board. The buildings, that is the part that is not included. Now those on the ground floor have obtained approval under Cap 123. It can be 2 stories or 3 stories. But if they build another one on top, they build a roof, and they argue that this is a single story. That is not acceptable, even if it is an approved structure, even consent has been obtained. The rooftop structure, the one marked in red, marked with red boundary, will not be accepted. A single-story building may be very tall, and there may be cock lofts. The cock lofts will not be accepted. Now, having spoken on the definition, I will now move on to the licensing requirements. If it's a new application, then we can refer to sections or clauses 13 and 14. There are many requirements. There are basic requirements, including requirements under building requirements. As for pre-existing pre-built columbarium, they have to be dealt with. As for pre-built columbarium, we can allow some flexibility. The best thing is to comply with the building's ordinance. If the building has been certified, is certifiable and has been certified by APRSE, then the licensing board may decide not to refuse the application. As for application for an exemption, one requirement is that it has to comply with building-related requirements. If it can't, then exemption for pre-built columbarium after certification by APRSE, an application can be made to the licensing board, and the licensing board will consider such an application. We are rather tight in the arrangement. If a columbarium, a pre-built columbarium, is given a license or an exemption certificate, then the columbarium has to comply with certain conditions. All the necessary and ancillary facilities. Only those that are necessary and related are ancillary facilities are approved. And they also have to provide a clear plan everything is put on the drawing, and nothing else can be built other than that is shown in the drawing as approved by the licensing board. The board can also impose building safety conditions. A report or certificates have to be obtained from the APRSE to ensure that building safety is complied with. We are reasonable, but we are strict. Now the columbarium has to comply, the pre-built columbarium has to comply with building safety. And there should have been ashes interned immediately before the 8 a.m. On the 18th of June 2014, i.e. the cutoff date. Now that is also, all these are also attached to the designated document. That is to make sure that pre-built columbarium will not go beyond what is shown in the document. So there will be no deterioration of conditions. This is by and large the framework of the bill. And we will also issue guidelines in the future for the trade and other stakeholders. That's the presentation. Thank you. Thank you, PAS, for giving us the presentation on building-related requirements, a very detailed presentation. At the previous meeting, we discussed the validity period and also consumer protection in respect of the contracts entered into before the contract entered into in respect of pre-built columbarium or columbaria. Do members have any questions? Wong Kwok Hing and Mr. Leung Chi Chung. Okay, 5 minutes each, okay? 5 minutes each. Wong Kwok Hing. Thank you, Chairman. Can ultimate slide of the PowerPoint. Tight regulation. That is cut-off date. 8 a.m. 18th of June 2014. The structure with ashes interned in niches. Evidence is very important. How do you consider the evidence? Will you consider bogus? How can you decide whether the evidence is bogus or true? For example, concerning how do you know the ash has been interned? As for application for license, there will be limited adjustment or adaptation. With regard to the pre-Columbaria, pre-built Columbaria, there is suitable adjustment so that even if they don't comply with the building related requirement, as long as the structure complies with the certification of APRSE, that will be considered. Would that lead to a lot of disputes? Thank you, Chairman. Thank you, Mr. Wong, for the question. Concerning the proof of the pre-existence, the onus rests on the operator. The operator will be held liable if he presents false evidence. In the bill, we do have a notification system. After the 18th of June, the FEHD contacted all Columbaria that could be contacted. They took photos. They made records. The licensing board will have information for reference. The operator is also required to provide information to the satisfaction of the licensing board. On the 18th of June, we took a snapshot of the situation. As for adjustment or adaptation, it doesn't mean that they can change in whatever ways. Well, in fact, I refer to definition 5, and that is structure that can be certified. As far as the use of Columbaria is concerned, and they have to comply with all these conditions before the application can be considered. They have to comply with all these conditions. It's not that they can choose whatever they can do whatever they like. Now, on the 18th of June, or after 18th of June, not before. Now you took evidence. Say if there is an application which is outside the snapshot, will you consider that? Now, there is also a provision which provides for that, but they have to prove that before 8 a.m. on the 18th of June 2014, the building, the structure was a pre-existing Columbaria. They have to explain why they have not participated in that. In fact, there was a notification mechanism requiring them to provide information. They didn't provide any information, so they have a lot to explain why they do not provide the information beforehand. And if they make false representations, that's a criminal offense. Leung Chi-Chang and then Che Wei-chun, Tony Chen. Now, concerning the approval of certification of buildings A, B, and C, you can accept APRSE certification. They certify that the building is safe.
So allow me to view it this way. Taking conditions A, B, and C together. So at the time of the construction of the building, in particular in the NT area, there was no regulation whatsoever. That's why these buildings have been tolerated, because you are not able to demolish them, and therefore so long as they've been certified by the APs and RSEs, then they can apply to the licensing board for turning it into a columbarium. if that is the case, then that would give rise to a lot of disputes in the new territories because, well, these are buildings that have been built in the 1980s or 90s, and at the time there was no town planning ordinance. That's why these buildings were tolerated and they were not demolished. And of course, many people would like to turn them into Columbaria. And now, with this definition of certifiable buildings, then some buildings which are next to residential developments would still be able to put in an application. If that is the case, then how can you not expect the villagers to come out to protest against them? But then, despite the opposition from the villagers, you will still have to approve them because they have complied with all the conditions that you have imposed. So that would be quite a big problem. And of course, well, for conditions A, B, and C, I'm not sure if they work, but then I would be writing to you because it's not really good for me to spell out all the details because you might then be able to tell which building I'm referring to. But then if that is the case, then I'm afraid I cannot support some of these conditions for the approval of such applications because the profit margin for such Columbaria is very high. That's why many people are making preparation to comply with your requirements so that they can turn these buildings into Columbaria. And that would be a major problem. Another question that has been raised by Mr. Wong Kwok Heng, all right, I can just enter ashes into the niche, and how can you prove that I have not done that before the bill announcement? Because there are ashes that have been entered in funeral parlors and also funeral services companies. Well, they have been placed there long before the bill because they have been there to wait for a niche. Then if they apply to become Columbaria, would you approve that? Well, to answer your first question, well, the second question is you said that for the undertakers and so on. All right, we have another paper on undertakers and we'll be explaining in greater detail when we come to that. Well, to answer your first question first, we have to be very clear about this cutoff date. That is, well, 8 o'clock, 18th of June 2014. All right, after that, well, there is no question of them getting approval or a license if they have put up the structures or if they have run the Columbaria after that date. So we have already defined that. So that is the cutoff point. And we have to have a ring-fenced system. And also the licensing board would be looking at the individual circumstances in considering each and every application. It's not just about the building. There are other conditions. And in the end, the licensing board might not approve the application. So the licensing board will be serving as a gatekeeper. But that you have not made it clear as to under what conditions the licensing board would be approving the application. So long as you comply with the provisions, you can get approval. All right, they will have to get people to inspect the premises. Whether or not they would be allowed to run Columbaria, that would be another case. For example, there would need to be 2 means of escape under Cap 123 subsidiary legislation, and also the loading would also have to be compliant. So you don't have to worry about that because there are many hurdles before they can get approval. So the number would be restricted, and also is not sure whether or not approval will be given. The licensing board will be acting as a gatekeeper. And there are 2 more things. It's not like what the Honourable Member just said, all right, in the NT, all exempted buildings can be included. In fact, under A, B, and C, we have already made it clear that they have to comply with the relevant legislation. That is, well, under the Buildings Ordinance, NT application and so on. All right, you will have to look at the footprint of the building, how many stories it has. So these are very clear provisions, and you will have to comply with all the requirements. It's not that so long as it's in the new territories, then you will be able to put in an application. It's not true. So that would confine the scope of where they can be located and what types of buildings they can be. And there is another requirement which is very important. Well, we have got this notification system, and they will have to provide the information, and then we will have to conduct site inspection, and then they will also have to comply with the number specified. And the Development Bureau has also got this table. That is for the locations that villagers are most concerned about. We all know where they are. And of course, we do not rule out the possibility of any application being approved. But then, will we have to be concerned that there might be Columbaria located right next to residential developments? But then, under the notification mechanism with regard to the information that we have collected, it's not like what the honourable member just said. Yes? Well, even if you accept the application, we will have to ensure that the building is safe, and also we will make sure that the residents nearby will be able to give their comments before the application will be approved. So there is no question of any application being approved so long as it complies with the requirements. So if it's right next to a residential development, then I don't think that would be acceptable. So there are other considerations. Yes, Tony Chair. Thank you, Chairman. Of course, the bill is there to regulate pre-existing columbaria. In fact, I'd also like to ask this. Well, when you grant them a license or when you grant them an exemption, they will have to comply with some pre-established requirements. But then, have you conducted any assessment? Is there a chance that some of the applications might not be approved? So have you got any idea as to how many such unlawful columbaria there are out there? Because they are pre-existing ones. So a group of people might be affected. So I'd like to know a bit more about that. Second, you talk about application for exemptions. In fact, some structures might be compliant with the relevant provisions, and there is a chance that they might not comply with the provisions. And generally speaking, the BO would regulate the unauthorized structures that have been put up, and then the buildings department would clear them. So that's the power given to the buildings authority under the legislation. But then, if they can get APs or RSEs to certify that they can comply with some basic requirements, and as a result they would be allowed to continue to operate. So legally speaking, whether the structures would be deemed to have been approved or what. So in the law, you might have such powers. Does that mean that when the buildings department acts under the buildings ordinance, it would not be enforcing the provisions of the BO when it comes to these structures? And then the lands department would also be looking at the let leases, and it can also enforce the law by resuming the land or by evicting the occupiers. So do you have to change those laws as well? Or is it that under the spill, these circumstances would be tolerated for the time being? Because when it comes to unauthorized building works, you said that you would tolerate them for the time being, and those were administrative means instead of legal provisions giving you the power to exempt them for a while. So I'd like to clarify that with you first. Thank you, Chairman. Thank you, Mr. Chair, for your question. To answer the first question first, as to how many such columbaria there are out there. At the end of the day, it's for the licensing board to decide whether or not an application would be approved. We don't have any idea as to how many such columbaria there are out there, but then upon the enactment of the bill, there are ways to deal with the situation so that the situation would be under control. And in the past, we have also said that we have got some ancillary facilities, for example, for temporary storage and so on. So in the future, if we have a chance, we will be briefing you on that. But sorry, Chairman, let me barge in here because I'm concerned that under the licensing mechanism, they would come up with certain conditions in the future. But then I am concerned that in the future, if they don't want to create so many problems, then when they process the applications, they would be forced to make some concessions in terms of the situation. So I'm concerned about the political implication and so on. So we're talking about statutory procedures and a statutory mechanism, and after the provisions have been scrutinized by members, and if you find them acceptable, then there is no question of us making arbitrary decisions, violating or breaching the legal provisions. But then you talk about the licensing board, because the licensing board would come up with conditions on approval. So will they be more stringent, or will they be more relaxed, and so on? So we don't know. Will they consider the sentiments of the residents nearby, or what? So that's quite abstract. Well, we have got another paper on the clarity of the law, and then when we move on to clause-by-clause examination, members will be able to see what those provisions are, and then at that stage, members will be able to give their comments, and if you still are not reassured, then we can also discuss and sort things out by the time when we conduct the clause-by-clause examination. You also said that the structures would also have to be safe. We understand that because under Cap 123, the Buildings Department has statutory powers, and under the existing mechanism is also the law enforcement agent. We understand your concerns as to whether or not they will continue to violate the provisions. Yes, but then under the licensing mechanism, we will tolerate them for the time being. But then there is no question of them becoming compliant with Cap 123, because if you are non-compliant today, then you will still be non-compliant tomorrow. But then under the legal framework, we will process their applications, so we will tolerate them for the time being. It doesn't mean that they will become compliant overnight. As to the risk-based approach, this is nothing new, because for small houses, that's been the long-standing approach with regard to a risk-based assessment. And also on the exercise of powers. Well, there are other administrative means of enforcing the law, but now we have come up with a statutory mechanism so that everybody will have a very clear idea as to what the rules are. And then if they are granted an exemption for, say, 10 years, and if they continue like that, then logically speaking, does that mean that all right, on the one hand, we will tolerate their existence, and then on the other, we will try to take action against them? So how the power is going to be exercised? Well, the bill does have provisions. When we move on to the clause-by-clause examination, we'll be giving you the details. But then there is a pointer pointing back to the relevant legislation, so that when the parties look at the legislation, then they will have something to go by, so that they will find out what the provisions actually say. There is one part on law enforcement and how certain situations will have to be dealt with, because this is a complex situation, and then at the later stage, I'll be more than happy to brief you on the conditions.
Chairman, I want to wait in the queue to ask again. Mr. Lee Chao-yen. Now they say that they will tolerate, but this is against the law. And now you tolerate, and the Buildings Department, does the Buildings Department tolerate? They may say, I tolerate it, but the Buildings Department may not tolerate it. If that's the case, then why? Then should the Buildings Department take action? There are Columbaria which breach the land ordinance, the planning ordinance, and the buildings ordinance. They are doing business, making money by breaching the law. Now we hope that there is a piece of legislation to deal with all the unauthorized Columbaria. Those that breach the law should be penalized. In fact, they made a lot of money by breaking the law for many years, and there is no penalty. They just get away with it. Now you say there is rule of law, you want to enforce the law, but in fact, you just slapping yourself in the face. You allow them to breach the law. I know that you continue to tolerate them, so I find the proposal unacceptable. Those that breached the law should not be tolerated. After they have breached the law for so many years, you tolerate them. You just let them off the hook. So for those doing business, they can break the law for many years, and then finally the government will just let them go. On one hand, you say you tolerate. On the other, you tolerate it. On the other hand, you say though they are tolerated, it doesn't mean that they have not contravened the law. I oppose any contravention of the law. My question is, how can you say on one hand you tolerate it, on the other hand you say they have breached the law? Then the buildings department will also have to tolerate it. This is just like the unauthorized building structures of the village small houses, because they are strong and they are powerful, just like the business people. Thank you, member, and thank you, Chairman. At the start, we explained there might be different views. Now, when we conduct public consultation, we have received views that the government should be pragmatic and practical in dealing with issues left over by history. Different people have different views. Concerning dealing with non-compliance, if the license is revoked or the license has expired, then the departments can take legal action under the law. Before the bill was announced, the departments had been exercising their powers to do what they should do. If the community and the council agree to a licensing system, then how can this licensing system be enforced? That is open to discussion. Now, with the licensing arrangement, with the passage of the bill into law, then the FEHD will be authorized to take legal action, take out prosecution. That is a big step forward. I don't understand what you say. Even if the FEHD agrees on an exemption, can the buildings department continue to prosecute the operator? According to the bill, then it seems that you have adopted double standards. Logically speaking, if the licensing board approves a license and an exemption, you give tolerance with your right hand, and then it's not reasonable to beat them with your left hand. So in the bill, there are provisions to deal with the law enforcement by various departments, and they are in Part 10, and we can explain that to members. And Part 10 means they are not going to take any enforcement action. No. It spells out the conditions for law enforcement. It is very detailed. And if there is a chance, we can explain that there are provisions for that. Chairman, to put it simply, it will be inconsistent if you beat your right hand with your left hand, but in fact, you just losing your grip. You just throw up your hands. The buildings department will not bother, and the FEHD will not bother with the breaches. Are you just condoning all these? You say practical or pragmatic? In fact, you condone all these. I think Mr. Lee has stated his position. according to my understanding, there are unauthorized building works. Even if they comply later with Cap 1, 2, 3, they do something to comply with Cap 1, 2, 3, it doesn't mean that they become lawful. They are unlawful still. If it is unauthorized, it is unauthorized, even if you do remedial works afterwards. That is still unauthorized, unless you take it down. That's the issue. The PAS has explained part of it. Chairman, you're right. If it is unlawful, it's unlawful. But there is no enforcement. There is no enforcement. Full stop. Now, there is a mechanism. This is an existing building. Even in the urban areas, there are unauthorized building works. If you did it before approval, it's still unauthorized, even if you have rectified it afterwards. According to the buildings ordinance, they are allowed to exist. Yes, you're right, Chairman. You may follow up. I just want to clarify my understanding of the matter. You say right hand slapping the left hand, recognizing unauthorized buildings. Well, they are existing buildings, and we have to deal with it. We have to deal with them. If we just tear them down, where do people put the ashes? Ms. Albert-Chan. Chairman, thank you for the supplementary remarks. I want to stress 3 points. They have to do a lot of things. They have to get certification by APRSEs. And each case will be considered according to its own merits as to whether approval is given or not. The licensing board. And number 3, the licensing board can impose conditions. There should be no deterioration, and there should be regular reports. This is a regulatory regime. The situation will not be worse off. Yes, we are very concerned about this. Ms. Albert-Chan. Chairman, I think we need to deal with it, deal with the details. We shouldn't just talk about principles. Otherwise, we are just beating around the bush. There are many types of breaches. What are tolerated? What are remediable? The administration has to specify them very clearly. Say, for those who occupy government land, say in Tuen Mun, we've been complaining a very long time. Government land next to a monastery. The monastery occupied government land and built Columbaria. Do you tolerate them? And there are Columbaria barrier in private buildings in the urban area, and they were monasteries, but they are in breach of the deed of mutual covenant. How many of these you have to list the categories? There are 6 or 7. 6 or 7. Some in industrial buildings, some in very small houses, some in private buildings, some in licensed houses, some on farmland, some. There are many categories. You need to list them, and what is the administration's position towards these different categories. There are those on government land by illegal occupation or unlawful occupation should not be tolerated. Some Columbaria may not fulfill certain conditions, but they can be rectified. Then such rectification should be done within a certain period of time. You should require them to rectify the situation. Otherwise, that may jeopardize other people, and that may cause a management problem. There are, say, Columbaria in private buildings. the Columbaria may not, to a certain extent, be in breach of the DMC, but if they burn incense, that is in breach of the DMC. If people burn incense in the Columbaria, in private building, then that is in breach of DMC, and such behavior cannot be tolerated. You need to spell out the problems, their category, according to their categories, and what is tolerated, what is not tolerated, what's the extent of the toleration. If you can tabulate that, that will be easier for us to discuss the matter. Otherwise, we are just discussing different things. Thank you. To answer Mr. Chen's question, there is no compromise on safety. I think Mr. Chen is talking about another area. Now, as for buildings, that's about statutory requirement. As for land condition, it's the relation between the land department and the lessee. As for DMC, it is a contractual relationship among the owners, private owners. They are not related to building safety. As for the lease, amendment to the lease has to get the consent of the government. You mentioned Tuen Mun. The Lands Department, well, I'm talking about what is tolerated and what is not tolerated. Please do not digress. I am not. The information you ask need time to be collected, and we try to see whether we are able to comply with your request. As for the lease, it's a relation between the Lands Department and the lessee. Amendment of contract has to be agreeable to both parties. If they apply for a license, even if a license is given, then the operator has to pay a premium. That's in the electrical brief. I do not repeat that. As for the DMC, section clause 17(2)(a) says that the board must have regard to public interest. Just answer my question simply. Whether you will exempt it or not, if it is in breach of the DMC, you have to look at the individual case. If you say if it breach, even if it breach DMC is tolerable, then it's public power overriding private property. I think that is provision. That is provision in the bill. That is a point of intervention. Is there a lawyer here? Are there any DOJ representative? If it is clearly in breach of the DMC, say it cannot be used as a monastery or it cannot be used as a columbarium, can that be exempted? Ask your lawyer. It is clearly in breach of DMC. You have to tell them that it's in breach of DMC and you will not give exemption. If there is doubt of whether or not it has breached the DMC, then you can look into that. But if it is not, Mr. Chen, I know your style. Now, for effective operation or proceeding, I will give you ample time to give your view. But if you keep on talking so that the meeting cannot proceed, that will not be desirable. Government Council, can you answer Mr. Chen's question?
Under clause 23 of the bill, only where an application can comply with planning requirements will the application be approved and a license be issued. And the relevant provisions are in Schedule 2 of the bill, and it says that it actually has to comply with all the requirements under the town planning ordinance. What about the deed of covenant? Well, under clause 14, there are some flexibilities. That is for pre-existing Columbaria, appropriate considerations will be given to that. That will have to be changed. So you can refer to that, and we can also spell out in detail as to the circumstances under which consideration will be given. In fact, in the bill, you will be able to find the details. If that is the case, then Secretariat, please note that down so that when we come to clause-by-clause examination, this part will have to be dealt with. There is no chance that the administration can have this flexibility or discretion to override the deed of covenant, so that structures can become tolerable and permitted. In fact, the licensing, according to the licensing authority's experience, well, where there is public interest involved in the process, the applicant might have shown the deed of covenant, and as Mr. Albert Chan just said, if it's proven to have breached the deed of covenant, then the licensing board would indeed reject the application. We did have such cases. I'm not on whether the structures would be approved. I'm talking about being tolerated. So how can you tolerate such operations? And also the nuisance that might be caused to the residents. In the bill, there are also very clear provisions. When the licensing authority approves the granting of the license, and also when it grants the exemption, certain conditions can also be imposed, whether it's in the license or in the letter of exemption. There is also a clause saying that the operator will also have to ensure that the operation of the columbarium will not cause any nuisance to the community. For example, they would not be allowed to burn incense, or they will have to do it indoor. They can also use modern day technology so that there is no smoke. In fact, I think we are talking at cross purposes. I think she is not answering the question at all. Well, Chairman, when you chair the meeting, you will have to make sure that the officials will answer or address members' concerns. Chairman, I'd also like to ask this question. It's a matter of principle. And for the detailed provisions, when we come to clause by clause, we'll be able to see that. But then the most important thing is, as I've also said earlier, all right, on the one hand, you're giving them the license, and on the other, you are not tolerating their operations. So I don't know how this can be dealt with in terms of jurisprudence. Well, for tolerated operations, usually you would be allowing or empowering the official or the law enforcement agency to exercise the discretion, and of course there would be different considerations in exercising such powers, and there is no clear provision on how that discretionary power should be discharged. All right, you're issuing the license and you're tolerating the operation, but then in doing so, the licensing board would be looking at different considerations in granting the license. In principle, you give people the impression that the licensing board will have extensive powers, and to the extent the powers are so broad that this person might have breached different pieces of legislation. And yet, you're giving people the impression that it doesn't really matter. I can still tolerate that. So, in terms of the enforcement of different pieces of legislation, are you saying that the officials concerned would also be tolerating that? Because in issuing a license, you said that the license would be for 10 years. We also talk about that, and apparently, well, to a certain extent, that would also affect the other law enforcement agencies in exercising their powers. So if that scenario has arisen, then does that mean that we have got precedents in the past that this piece of legislation will override other pieces of legislation to an extent that other enforcement agencies would also have to tolerate that because of this piece of legislation? Or is it that they will also have to look at the provisions of the buildings ordinance, and if you're saying that you're going to tolerate that, then there should also be a time limit? So how does this work? So you're coming up with a piece of legislation which would override other pieces of legislation, because an official who used to have the power over certain things, now this power will be given to the licensing board, and then the licensing board will be able to do certain things which would affect the exercise of such power by the other law enforcement agency. We also refer to the deed all right, for private Columbaria. Just now we were told that 7 were operating on unleased land. So are they still continuing with the operation, or have you taken enforcement action against them because they are not really running the Columbaria on their own land? And if you also tolerate that, then inevitably you would be giving people the impression this, all right, you've already got this cut-off point, but then to a certain extent you would also be giving people the impression that despite the fact that they have violated the provisions, still the government would be prepared to tolerate that. So you're actually succumbing to pressure from these operators. Is that right? Ms. Wong? Thank you, Mr. Chair, because what you said just now would also involve very complicated situations, and Part 10 has provisions on that, and please allow us to provide additional or supplementary information on that. So I am concerned about the jurisprudence, because as a matter of principle, how would that work? So without going into the details, I'll be talking about the general points. I can give some other examples. For example, under the TPO, when it was first enacted, before the first statutory plan was published for pre-existing uses, they would also be tolerated. All right, that's under the TPO. We are actually moving on to that. Well, under Part 10 of the bill on planning and lands and also building requirements, they have this flexibility. So the provision says that they do not apply, but then of course the licensing board would be the gatekeeper and it would be looking at different situations. I'm not referring to that. Well, as I just said, you said that there are areas which will not be applicable. But then does that mean that the buildings ordinance would also have to be amended so that, well, under a particular legislation, the licensing board would be able to overrule the buildings ordinance? Is that right? I think the biggest difficulty encountered by this bill is exactly what you said, because for these structures, they are already in existence objectively, and now you're trying to resolve these problems by enacting this legislation. And then upon the enactment of the bill, the licensing board will definitely have to be given the power to relax some of the controls under the existing legislation. So the legal advisor will have to give us a comment or advice. That is, with regard to the existing BO, there would be implications. So do we have to amend the BO as well? All right, I'll supplement and then I'll defer to the legal advisor. In fact, that has been provided for under the bill, but then as I said, there is a pointer pointing them to Cap 123, and they would also be pointing to Cap 121, and therefore the board will also have to make reference to Cap 131 and 123. So they would be looking at this provision. Okay, legal advisor. Thank you for your question. In fact, if we can look at Part 10 and Part 11 of the bill, there are some flexibilities or discretionary powers whereby certain rules do not apply. And when we come to clause-by-clause examination, members will be able to take a look. And they are very complicated. That's why I cannot just come up with a general statement as to how this would apply. Yes, of course, you may refer to certain pieces of legislation. Does that mean that it's okay to refer to them just in this bill instead of having consequential amendments to other pieces of legislation? In fact, part of them have been contained here. So some consequential amendments have been included here. So there are amendments to other pieces of legislation. So when we come to that, we can also discuss that in greater detail. All right, I'll be following up on that later. In fact, I'm using my own time. I'm not using yours. In fact, there is an overriding principle that is about Columbaria on government land. So that is a major point. So how are you going to deal with that? In fact, that was also put to us at the last meeting. In fact, on land leases, there are certain procedures, and they will have to go through certain procedures, and they can apply for that. And as we said, whether or not they can get the approval upon application, the two sides will have to agree on that, and therefore those will be dealt with in accordance with the general rules and regulations. What does that mean? So they can put in an application, but then they've already occupied the land. Yes, in other cases, that would be the same. They've already occupied government land, and then they will apply to the Lands Department as to whether or not the Lands Department would grant approval. And of course, it depends on how the negotiation goes, and the Lands Department is empowered to grant approvals or otherwise. But then they've already occupied government land, and they are already running this columbarium. So would they be phased out or evicted because the land does not belong to them in the first place? So are you going to take enforcement action against them? All right, if they've occupied government land at present, and these are pre-existing columbaria, and therefore under the bill, they will still have to put in an application and they will have to be processed. So it doesn't mean that so long as they have occupied government land, their application will definitely not be approved. Is that the case? So I'll defer to the Lands Department. Yes, Ms. Lam. Thank you, Chairman. Thank you, Mr. Chair, for your question. Just now, Mr. Chair also said that at the last meeting, there were 7 cases in which the columbaria operated on unleased land. So some of them are covered by other pieces of ordinances or other ordinances. So it's not a question of occupying government land. As to the details of those 7 cases, I don't have them with me now. But then it's not true to say that they are unlawfully occupying government land. So what does that mean by occupying government land without authorization? Well, there were 7 cases mentioned in the last at the paper submitted last time. So I'm not saying that other than those 7 cases, there was no case involving an occupation of government land. Well, lawmakers have not been legally trained. We are just representing public opinions. So we are just the representatives of people. All right, on the right to use a certain piece of land. All right, if breach the conditions and you are not banning their operation and you are not evicting them, forcing them out of the land, and the fact that I have to get up so early in the morning, that's because I have to safeguard the interests of the residents. I think that these operations are causing a lot of nuisance to the residents because all of a sudden they're operating there, and that has caused a lot of nuisance and disturbance to these residents, which are not tolerable to them. And I don't know how you're going to describe them. All right, you might call them unlawful occupation, or they have not occupy or use the land properly. All right, if you do not ban such operations, and if you tolerate them, and if you allow them to publicize them and invite people to use them, then, well, even if they go to the TP, the Town Planning Board, to apply for the change of land use, that would not be permitted. So you're actually allowing them to cheat. So when I watch APIs, we've been reminded that if you've been asked to loan your cell phones to them, and if anyone calls you up telling you that long hair is in trouble, then you should just ignore them. But then you're actually allowing them to cheat people out of their money. And it's not just about cheating people out of their money. You're actually allowing them to put or enter ashes into these columbaria without protection. And of course, this has to do with your legislation. I don't know how it works. But then, Chairman, can you just ask the question on my behalf? Well, after what I've heard so far, is there any way that they can preempt such operations? So if we have to wait until after the enactment of this legislation, the situation might become very bad. So, Chairman, I might die before I can see the enactment of this legislation. So can you tell us which columbaria or which columbarium I should go to? Well, one of the important points of the legislation is that upon the enactment of the legislation, for anyone who would like to operate a columbarium, they will have to get a license before they can sell those niches. So in simple terms, if they sell niches without a license, then we can take enforcement action against them. But then today, in the absence of the law, indeed, there are columbaria which are not properly run. In other words, that they are selling the niches and they are telling us that they would be complying with the town planning requirements and so on and so forth. So that's a problem. And upon the enactment of the legislation, they will have to be licensed before they are allowed to sell the niches. And if they fail that, then we'll take enforcement action against them. That's the distinction between with or without the legislation. And I believe that that is an important difference. And I'd like to point that out.
Much time was devoted to existing problems. The law may not be able to deal with all the problems left over from history. The general direction is to contain the problem and regulate the columbaria. It doesn't mean that all columbaria can remain. If there are certain problems with certain columbaria, finally we may not give a license or give exemption certificate to a particular columbarium. If there are problems, we expect that there can be some improvements. Say, for example, on the second floor of a structure, there may be niches, but we will not allow that in the future. This will gradually contain and compress the problem. Chairman, he has given a very clear answer, and that is there are existing problems. Some people know that in the future they can't do business. They keep applying to the town planning board. If you cannot stop their business, well, just ask them to introduce. There are 6 officials here. Ask them to tell me, to introduce a proper columbarium to me. I'm getting old. I need to prepare for that. Well, we're discussing the law, but we are afraid that the niche we bought is not safe. That's the problem. Now you've seen the loopholes. Are you going to plug the loopholes? Now the lawyer said, there are 7 which the law which would not be acceptable under the law. Well, let me answer Mr. Leung's question.
非法佔用未批租土地啦。
Now concerning illegal occupation of unleased land. We will continue to enforce the law. Now, before the bill becomes law and takes effect, each department will continue to enforce the law. It depends on the circumstances of the case. It depends on the availability of evidence. Among the examples, there were enforcement actions taken. In Tuen Mun, we had already taken action under Cap 28. We prosecute the operator for the 5th time. On the 13th of February, the case would go before the court again. If you do business in Hong Kong, you need to comply with the Trade Descriptions Ordinance. There is no exception to the columbarium business. In our publicity, we've already told them to comply with the Trade Descriptions Ordinance. Mr. Lee Chao Yan. Well, they are still in operation. Even if you have prosecuted them for the 5th time, you should get an injunction order, which is as good as using the injunction order to stop the occupation movement. Mr. Lee Chao Yan. We need to keep the time. Mr. Leung has overrun. He has made use more time than he is allotted. Mr. Lee Chak-yan, I think part 10 is problematic. They better withdraw it. I have a question for the Buildings Department. 24 bracket 1 and 24 capital C. What do they refer? Concerning those breaches, the administration should provide a table which categorize the contraventions. When I see the word modification, I got goosebumps. Modification means just ignoring the law. Breaching the land ordinance, breaching the buildings ordinance, breaching the planning ordinance, all are contraventions. Which provision is breached under the buildings ordinance, under the planning ordinance, under the land ordinance? Now, say for example, you can do some matching. Say Kek Lok Chi or Kek Lok Temple. It occupies government land. It has breached the buildings ordinance. You can show us examples. Everybody knows that. Zhonghuo Monastery. It has reached planning ordinance. But by making use of the loophole of the planning ordinance, they apply 7 times to the town planning board. They keep dragging the feet. And now you're going to legalize this operation. They may get an exemption. The Yinheng, Namtin 以及半出園 there are 佛教人士 monastery, 中和 monastery. Now you can match the breaches with the relevant institutions. And we know that you may consider, according to the law, allow them to apply for a license or an exemption certificate. Then we will assess whether that piece of that the bill can be endorsed. Well, if they occupy government land, and then they can make application, and then you will give approval, then you better tell us so that we can do it. We can run a social enterprise. Let us run a social enterprise on this. Yes, by a joint venture. Tommy Chang and Lee Chak-yan occupy government land. Tommy Chang knows that very well. We occupy government land, we make money, and then we get exemption. That's really absurd. So give us a table on the types of categories of breaches, and also what provisions are being rendered useless by this private Columbarium bill. Concerning Part 10, we will provide supplementary information. From Section 96 to Section 100, there are detailed provisions, and they also spell out which provision of the law will not apply. Not every provision is disapplied, but the most important sections are not applied. That's the crux of the matter. Well, we're not talking about individual cases. In the future, the licensing board will make the decision. We cannot preempt the licensing board. They may make improvements. They may rectify the situation. We will provide supplementary information to explain the sections. They refuse to match the cases with the breaches. You cannot preempt the work of the licensing board, but you can say that this Kek Lok Temple, we want them so many times. We and also the Zhonghua Monastery, they breach what rules? How many warnings were given by the planning department? And we can match that. Right. The LegCo did ask us to give progress reports. Say we can report to you the actions taken by the various departments, orders issued by departments. I think members want to know the assessment of existing cases so that they can consider whether to support the bill or not. Please consider Mr. Lee Cheuk-yan and also Mr. Albert Chan's requests so that we can have a comprehensive understanding of the bill. Please consider how to present the information they request, and also the two provisions in relation to the buildings ordinance. Can they be more specific? Thank you, Chairman. Let me respond to Mr. Lee Cheuk-yan's question. The relevant sections deal with the issue of clearance, orders, warnings, and notices, and register such documents with the land registry. They do not apply in respect of any non-compliant structure. But when there is a danger, then we can take action. So they will be tolerated. They will not be cleared. Mr. Kenneth Chan, concerning the questions raised by members, they are long-standing questions. When the previous term of the government or previous term of the government of the previous term continue to allow the Columbaria, we were worried then. Now we are to tidy up the mess. If you look at this thick bill, you can see one provision after another to deal with that. I thank you for your project, your PowerPoint. The question is those under Schedule 2, they've reached the law, they've reached the buildings ordinance, they've occupied government land. How many Columbaria will not be given any license or exemption? Why your answer is so clumsy? Now you say there are ashes interred in these unlawful Columbaria, so should those niches, should those urns be put in front of the government headquarters? So they have the word modification. Let the licensing board to discuss that and then pocket them first. I think members are concerned under what circumstances you can turn a gray area into an area which is not gray, and that is the modification. What are the factors? The licensing you spell out the factors the licensing board will have to consider. I think we should go into this thing deeper. If we should be more specific and discuss the bill. As for discussing principles, they are just out of touch with reality. Now, for the people, they have a very firm view. If it is in Schedule 2, if it is in breach of the law, then no license will be given. So we really need to pin down on the details, in particular with reference to the bill. I'm not too worried about licensing, but you also have exemption, and you also have the staying of implementation of the conditions. I'm really worried about it.
So if we do not do our job, then I think we will not be living up to the aspiration of the public who have been affected and who are very concerned about this. And maybe the trade is also feeling very frustrated too, because we are still arguing about the matters of principle here, while the situation on the ground has not been dealt with. All right, as far as the residents are concerned, they would like us to regulate the situation so that they would not proliferate on the ground. So I think the stance has been very clear, and I'm sure the administration has heard the message. And how can the administration help us with our work? I think we have got Schedule 2 here, and we've been told the situation, to what extent they are breaking the rules and regulations. All right, we have got this very thick blue bill, so without affecting the future establishment of the so-called licensing board. So on that premise, well, under the proposed bill, for those pre-existing Columbaria which are breaking all the rules and operation and regulations, so will they be able to get exemption from the licensing board in the future so that they would not be held liable, and in certain circumstances they might even be issued with a license? And then for those who have been affected, and also for members who are serving as a gatekeeper, then when we look at those provisions, we'll be able to focus on those provisions. We'll be able to see under what circumstances these operators will be able to get a license in the future. That would help us in our work. Chairman, I agree with the way that Mr. Chan has proposed. In fact, conceptually, generally speaking, we can set out those provisions. We have already discussed the general issues. We know where we stand. We all know our respective positions, and of course we are entitled to our own views. So when we move on to the clause-by-clause examination, then we'll be able to be more focused on how the situations can be dealt with. Well, just now you also talk about the TSOL. In fact, initially, when we require them to try to comply with the relevant provisions, that's why we are giving them time to comply with the relevant provisions. That's why we will give them just 3 years to do that. So in doing that, we're just giving them enough time to comply with all the regulations. So it's not that we are not going to enforce the law at all. Chairman, I'll be very brief because I understand that other members have got many questions too, and I'm not here to argue with them, because all we are trying to do is to get on with the clause by clause as quickly as possible. But then, well, when we go out, there might be sales approaching us, telling us that they have been exempted from the legal liability. So you will have to understand the culture out there and also the environment under which they are selling these niches. And it's not like what we are doing here. We're just discussing and debating very rationally here about the rules and the principles. So can the administration also help us? Well, of course, I can also do that for Schedule 2. For those that are breaking the law, they are already here. They've got the names and so on, and everybody knows about this. And under the Blue Bill, according to your proposal, how can they become lawful again? So can you provide us with such information so that would facilitate our work by engaging in a more focused discussion? In fact, the starting point should be to get back the progress reports as to what rules and provisions they have broken, and then what actions have been taken by the departments concerned. As you said, in the end, it's up to the licensing board to decide. So how can we facilitate public discussion and understanding of this? As to why we are not able to move on to the clause-by-clause as quickly as possible, because there are many matters of principles that have to be sorted out before. So I'm sure members would understand, given the fact that this is a very thick blue bill, every part of it will have to be scrutinized very carefully. That's why a lot of efforts will be required, and a lot of homework will have to be done. So it's not that we don't want to move on to clause by clause right away, because there are many matters of principles that have to be sorted out first. Mr. Albert Chan, I hope that the administration can come up with a more detailed table involving the leases and the buildings, and some have operational problems and so on, and some might have breached many rules and regulations in different respects. And what's the government's stance on this? On what interim measures will be taken? what kind of interim measures will be taken. So you will have to be very careful. You will have to seek legal advice first, because if there is a breach of the conditions of the deed of covenant, I think there is no room for maneuvering. You will have to reject it, or else you'll be sending out a wrong message. That is, even if you break the deed of covenant, there is still room for negotiation. I think that is an abuse of public power, because if there is any landlord who has broken the deed of covenant, in fact, if you seek an injunction, you'll be able to get an order right away. But then, if you allow that or tolerate that, then you'll be unfair to the small landlords or owners. And if you say that that would depend on the circumstances, then it means that the administration will be favoring the operator who doesn't have the power in the first place under the law. And then in doing so, you're actually depriving the rights and powers of those others under the law. So you have totally ignored the basic rights of private property owners. So how can you say that even if there is a breach of the deed of covenant, you will still tolerate that? I think it simply cannot stand, and I hope that the legal advisor can give us a paper. You can give us an advice to confirm what I said was right. That is, if you can still process the application even if there is a breach of the deed of covenant, then that would lead to an explosion of public sentiments. There would be a public outcry. And also, I also raised a matter of principle, and we gave a comment, and that's about the licensing system and also the ownership of such Columbaria. At the time, we said that in the future, in issuing a license, that's my personal opinion. All right, there can be different gradings, or there can be a multi-tier licensing system, which will integrate with the land ownership system. If you just issue a license to the operator, and then for the person buying the niche, and if he doesn't have any ownership of the land, then that would give rise to a problem when the Columbaria close their business and so on. So that would also affect the niche owners. All right, the views have been expressed very clearly, and then we'll deal with that later. But just now, that was Ms. Koh, not Ms. Wong, right? Well, for the legal advisor's views, I think that's okay. But then Ms. Wong, in her answer to my earlier question, I was outraged by her reply. I'm not referring to the reply given by the DOJ representative, because I could not condone to the attitude adopted by Ms. Wong. Mr. Wong Kwok Heng, Chairman, what I'd like to say is that in the future, when the administration submits further papers to us with regard to the PowerPoint that they have prepared, I think they will have to be more careful, because the way you have put it here is that you said that there would be limited flexibility or discretion given to the relevant authorities. I think that would give rise to some unrealistic expectation on the part of the potential applicants, and they would fantasize as to what they might be able to get away with. I think politically it's not correct either, because in the future, when these operators put in an application, well, where they are operating their Columbaria, if it's lawful, then it's lawful, and if it's not lawful, then it's unlawful. So there is no gray area. And if you say that there would be limited flexibility to be exercised here, then that would give rise to a lot of fantasies or imagination. So what does that mean? So to what extent would you have that discretionary power or flexibility? Does that mean that for the bill to be enacted, does that mean that by saying that there would be flexibility, it means that you can depart from the legal provisions, and that would give people an impression that you might be abusing the power, or there would also be decisions to be taken by the individuals which are not entirely in line with the law, and that would also have negative implications. So even though that has been written in the PowerPoint, I hope that the administration will pay more attention to your formal papers in the future. Please do not put it that way, and please do not think it that way, and please do not have that presumptions, because indeed that would give the public the impression that this will be the case, and they would criticize you for that, and I'd like to put that on record. But let me respond to that. In fact, if you look at the provision, in fact, it's very detailed and it's very clear. And when we read it, there would be no room for misinterpretation. But then, as Mr. Wong just said, for some quarters in the community, in order to do their business, they might try to misinterpret it. But then we will do our part. We will try to unify our stance so that the public will have a proper understanding of what those provisions are. With regard to self-owned premises or property, we have already explained that last time. If it's a brand new columbarium, i.e. they are not pre-existing columbaria, then they would have to be subject to the new rules and regulations. In fact, if it's not in self-owned premises, then they would not be permitted. And also on the deed of covenant, in fact, after the point was first raised, we had further discussions with this committee. Well, again, let me cite an example. That is for the deed of covenant. In fact, it's a contract between the owners, and in the past, some individual owners have managed to challenge another party for a breach of the deed of covenant, causing them to have to fold up their business, and as a result, the licensee had his license revoked. And of course, when we come to clause by clause, I'll be telling you as to how that would be dealt with under the bill. But then, even under the deed of covenant, private individuals have been able to challenge the operation of another owner. Well, I believe that when we do the clause-by-clause examination, we'll be able to discuss that in greater detail. I don't think it's as simple as saying that private individual owners will be able to challenge the deed of covenant. In fact, that would be very difficult. And that has to do with the buildings ordinance, and the conflicts have arisen before. We have to adjourn our meeting by 10:30. So one last point by Mr. Tony Chair, please. Thank you, Chairman. Well, I'd like the administration to further elaborate on this. They should have done an estimate. That is for the pre-existing columbaria. Some of them might not be able to get a license or an exemption. Okay, you said that you had no idea as to how many there will be in the future. But then I don't think that's the proper answer. Without doing the assessment, how can you go about your work properly? You talk about interim measures and so on. All right, we need some time to scrutinize the bill, and during that interim period, a lot of work can be done. At least you should try to make sure that fewer people will be misled, so that in terms of publicity and so on, you would have to work on that. And just now, you might not have had enough time to deal with that. So can you tell us more about that, as to what the administration plans to do, or what is being done right now? Because it's a historical legacy, and we are trying to resolve that historical problem. And then for the new ones, you'll be applying the rules very strictly. But then for some pre-existing ones, you will also have to conduct an assessment, and then according to your assessment, many of them or most of them will not be acceptable, right? There are 2 points about our estimate. Well, internally, we have done some estimates ourselves, and we have put in place some arrangements. And if there is a situation whereby we have to take over such ashes, we do have interim measures, and we have got some planning in place to do that. And secondly, about publicity, because the law might take some time to be enacted. That's why we agree that in the interim, we have to work on that too. Previously, before we introduced the legislation, we had already done one round of publicity, and later on, we will continue to put out more APIs. For example, the way they market those niches in the media. We will try to rectify the situation. So indeed, we need to take those actions, and we also hope that we can sustain those efforts. Thank you. I'd just like to add one point, Chairman, because we all know which are the existing columbaria, and I'm sure the departments would be monitoring the situation very closely, because during this period of time, people might be taking advantage of the loopholes. So there are many ways to go about this. And if you do not monitor the situation closely, the situation might proliferate. And the departments must not relax their efforts, or else that might give rise to more problems. I think that's a very good point. We all have an idea as to what the situation is like. All right, it's already 10:30. We have got this paper or submission from the coalition on the situation of Columbarium. I think the administration should come up with a reply or response to that. That would also facilitate our scrutiny of the bill. So that's my request with regard to the submission of papers. Well, in the past, every time when there is any written submission, we would always respond to that in writing. Okay, so meeting is now adjourned, and for the date of next meeting, we will fix the date and then we'll inform members.
Well, we've already passed 10:30. Well, I agree with Mr. Chen. We need to pass the bill within this session. We have a year to do so. We have a year to do so. That's a big bill. I think we can go. We can proceed to clause by clause very soon. Thank you. Meeting adjourned.